Thank you. Mr. Rahim.
Good afternoon. I will begin by outlining the serious constitutional problem with Bill C-16, ousting stays as the minimum remedy for a Section 11B violation. I will then suggest a narrow and targeted amendment to the alternative remedy framework. In the Section 11B context, a stay is a remedy granted under Section 24(1) of the Charter, which reads, "Anyone whose rights or freedoms is guaranteed by this Charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such a remedy as the court considers appropriate and just in the circumstances." In 1987, the Supreme Court of Canada ruled in R.V. Rahim that a stay of proceedings was the minimum remedy for a Section 11B violation. I will quote from that decision. Chief Justice Dixon and Justice Lemaire, "A stay is the minimum remedy." Justices Beets and Ledane, "I am of the view that a stay of proceedings is the appropriate and just remedy." Justices Esty and Wilson, "I believe that only one remedy, a stay of proceedings, is available under Section 24(1). In 2017, in a report on trial delays, this committee recommended that any legislated consideration of alternative remedies requires a constitutional reference to the Supreme Court, precisely because stays are a judicial remedy. A stay under Section 24(1) is not the result of a common law rule or the interpretation of ordinary legislation. It is the constitutional protection of a right guaranteed under the Charter for persons who are presumed innocent. To our knowledge, Bill C-16 is the first time since the adoption of the Charter that Parliament seeks to explicitly legislate the test for a judicial remedy under Section 24(1), in contradiction to binding Supreme Court precedent. It will lead, invariably, to intense litigation and uncertainty in the courts for both the accused and complainants. The precedent will also undermine the power of judicial review and the protections available for rights and freedoms under the Charter. Any suggestion before this committee that such an approach is sanctioned in the case law is incorrect. The Supreme Court has acknowledged that it may wish to revisit the Rahim decision, but the Court has also been clear that Rahim remains binding constitutional law until that time. The Chief Justice explicitly made this point in the case you have heard about before this committee, Verbanek. However, if Parliament proceeds with the alternative remedy framework, the CCLA suggests including one more factor under the new proposed test. The new factor would be prejudice of unreasonable delay to the administration of justice. The current proposed factors include the prejudice that has been or would be suffered by the accused or an offender as a result of unreasonable delay. This kind of prejudice was part of the test to establish unreasonable delay prior to the Jordan decision. It was jettisoned in Jordan because, as the Supreme Court noted, it was confusing, hard to prove, and subjective. And because, quote, "the public's interest in a trial within a reasonable time does not necessarily turn on how much suffering the accused has endured. Delayed trials may also cause prejudice to the administration of justice." The CCLA suggested amendment would recognize that prejudice to the administration of justice overall is also a legitimate consideration. Regardless of the specific effect on any single accused, where the justice system permits excessive delays, that should also inform what an appropriate and just remedy is in the circumstances. This amendment would not oust the other enumerated factors, but simply be one more relevant consideration. Thank you.